right. Hi, everyone. Welcome to our webinar on GDPR compliance essentials for SMEs. My name is Harmanjot Kaur, and I'm a senior associate in LegalVision's commercial and corporate team. Before we begin, a couple of quick housekeeping items. You'll receive the recording and slides in your email, so don't feel the need to frantically take notes. You can submit your questions in the Q&A box and I'll answer them at the end. And there will be a little feedback survey that pops up after the webinar. We'd really appreciate if you take the time to fill that in. For the next 48 hours, you're eligible for a free consultation with LegalVision to discuss how we can help your business. If you leave us your contact details in the survey at the end of the webinar, I'll have a member of our team reach out to chat to you about LegalVision and how it is that we can help you. So let's get on with it. Today, we'll be talking about a few things. We'll start off discussing what is the GDPR. We'll have a chat about what the rights under the GDPR are, what the obligations under the GDPR are, and then we'll do a bit of a deep dive into the lawful basis for processing before having a quick chat about what documents you need and going through some practical tips for compliance. And then we'll end with some Q&A. So privacy often tends to be the one area where a lot of businesses' regulatory compliance falls out of the window. But arguably, it is one of the most important areas to be thinking about. So what is the GDPR? Every business operating in the UK is required to comply with the Data Protection Act, which incorporates the General Data Protection Regulation, which you might otherwise know as the GDPR. If you're providing services into the EU, you'll also need to comply with the EU GDPR. The GDPR sets out the rights individuals have in respect of their personal data and how businesses must treat any personal data that they receive access to. One of the key themes of the GDPR is transparency, that individuals have a right to know and understand which of their personal data is being collected by a business, what purposes it's being used for, and how it will be stored and handled. So why is GDPR compliance actually important? There's a couple of things to think about here. Firstly, it gives you credibility. Individuals are more likely to engage with a business that they believe is acting in accordance with the law, and it makes you look good. It's an easy way of making sure that you're maintaining a reputation in the industry. More importantly, the consequences for non-compliance are huge, especially for an SME. It can have massive impact on your financial standing. The ICO is allowed to penalise businesses with fines of up to the greater of 4% of annual global turnover or £17.5 million for any breaches of the GDPR. So as you can imagine, that's quite significant, and particularly for a small business or a startup where you are still in the phases of building some of that financial runway, that can be quite a big hit. So the aim of the GDPR is to protect individuals when businesses collect, process or move personal data. It's to ensure that the individual is always aware of how their personal data is being used and to ensure that personal data is used fairly and lawfully, used for a specific purpose only and only when necessary. It's accurate, it's kept only for as long as necessary, and it's handled securely. In an effort to promote these principles, the GDPR gives individuals, or as they're known in the legislation, data subjects, a number of rights in respect of their personal data. Firstly, the right of access. This is the right to understand what personal data a business holds about them and receive a copy of it. So, for example, a customer might make a request to see what personal data you hold about them, and legally you are required to give them a copy of all of that personal data. There's also a right to rectification, which is a right to request that you update any personal data you hold about them to the extent that it might be incorrect. There's a right to erasure, otherwise known as a right to be forgotten. This is a right to have the personal data that a business processes about the data subject erased in specific situations. For example, a lead or former customer might ask that you delete any personal data that you hold about them. Now, it's important to note that this is not an absolute right. So just because an individual has asked to exercise their right to erasure doesn't mean you have to comply. The legislation sets out specific situations in which you are required to comply and situations in which there might be some exceptions that you could rely on. And that applies to all of these rights that individuals have under the GDPR. There's also a right to object to or restrict processing. And so that's to say to you, no, I don't want you to collect my personal data. Obviously, that comes with consequences, but that is a right that individuals have. There's also a right relating to objecting to automated individual decision making, including profiling. So that means that an individual has a right not to be subject to a decision based solely on automated decision making processes. For example, a bank that is taking online applications for a mortgage, if that application is entirely assessed by a robot, there is no human intervention, that is considered automated decision making. And individuals do have a right to object to that. There's also a right to data portability, which is a right to have the personal data a business holds about them to another data controller. So, for example, your customer might ask you to send the data you hold about them to a new supplier. So what should you do if you actually receive a request from a data subject? An individual wanting to exercise any one of these rights can reach out to you however they want. This can be through your social media accounts, via an email, over the phone. They can come and visit you if you have a storefront. There's no restrictions in the GDPR as to how an individual must exercise these rights. So as a business owner, the onus is on you to ensure that your customer service team is trained on the GDPR and they know what to do when you receive a request from an individual. You don't want someone coming into your storefront and asking to exercise a right to personal data and your employees simply telling them to go away. If you receive a request from an individual to exercise one or more of their rights, typically you must comply with the request within set timeframes. It varies from right to right, but it is usually about 30 days. You should ensure that such requests aren't ignored or deleted, and we recommend that you engage a lawyer that can help you with your responses. It's also important to note that where the request relates to a right of access, so where they've requested that you provide them with a copy of all of the personal data you hold about them, you shouldn't be deleting any of that personal data because that could also be considered a breach of the GDPR. There are certain situations where you don't need to comply with the data subject request, as I kind of alluded to a little bit earlier, and a lawyer can help you figure out exactly how or when to respond and what to respond with. It's also important to note that you can't typically charge the data subject a fee to respond to their request, except where their request is manifestly unfounded or excessive, meaning they've made repeated requests for the same information. So the GDPR has concepts of a controller and a processor, and your obligations under the GDPR will differ based on whether you are a controller or a processor. A controller is the party that determines what personal data to collect and how to process that personal data. For example, your business would be considered a controller if you collect contact and payment details from a customer so that you can provide your goods or services to them. On the other hand, a processor processes personal data on behalf of the controller and does not determine how to process that personal data. So they're only doing it because a controller has asked them to do so. For example, many B2B SaaS businesses, such as MailChimp, Stripe, or Xero, are considered processors when they are instructed by their clients to process personal data in a particular way. So where you use a Stripe payment gateway to collect payments from your clients, Stripe should only be using the details that they receive for the purpose of providing the payment gateway services and not for any other purpose, such as contacting a customer to sell them Stripe's own services or such as marketing. It's important to note that you can be both a controller and a processor in different situations. So, for example, if you're a B2B SaaS business, you would be a controller where you collect personal data from your customers to sign them up to your services, but a processor when those customers then store their own end client data in your SaaS solution. So, it is possible to be both. Now, there are a number of obligations of both controllers and processors under the GDPR. We don't have time to go through all of them in detail today, but we'll highlight some of the key ones. So some of the shared obligations of both controllers and processors to implement security measures, both organizational, such as internal policies, and technical, such as software, to protect personal data. You should have appropriate contracts in place between a controller and a processor, or processor and sub-processor. We'll talk a bit more about what those contracts look like, but typically it would be a data processing agreement. Another shared obligation is to appoint a data protection officer and or an EU or UK representative, depending on where you're based and where you are providing goods and services. In addition to that, so there are some of the things that both a controller and a processor need to do. In addition to that, if you're a controller, you need to identify a lawful basis for processing each piece of personal data that you collect and process. And we'll talk in a second a bit more about what the lawful bases are. You also need to have a compliant privacy policy in place. You should familiarize yourself with and respond to data subject requests. So that's some of the rights that we've just gone through, what those rights actually are, and then how you would respond in the situations should any of those rights actually need to be exercised. You should also conduct data protection impact assessments if you commence any activities that are likely to result in a high risk to individuals' rights under the GDPR. And then you also need to pay an annual data protection fee to the ICO. Now, if you're a processor, some of these obligations are different. Some of the obligations you should comply with if you're a processor. You should only process personal data on the instructions of a controller. So if you receive personal data because you are a SaaS provider and a controller has input their end user data into your SaaS solution for whatever reason, you can't then use that personal data to go and market your own services. You only have access to that personal data because the controller gave it to you and they're instructing you to store it for their use of your software. You should also assist the controller with observing their obligations under the GDPR, including responding to any data subject requests or helping them to conduct any data protection impact assessments. Additionally, you need to obtain consent from a controller before you engage any sub-processors. And then you also need to be making sure that you notify the controller of any personal data breaches. And that obligation does go both ways. Where a controller has a data breach, they should also be notifying their processor to the extent it relates to any personal data that they might hold. So as we briefly touched on earlier, one of the key obligations that a controller has is to identify a lawful basis for their processing of personal data. The lawful basis which you can choose from, there's about 6 of them, and it has to be one of those. So you can't choose a lawful basis outside of these. The reason that you're processing personal data needs to fall into one of these categories. The first is consent. So the individual or the data subject has consented to you processing their personal data. In this case, consent needs to be express. So it needs to be via an affirmative action. It needs to be knowingly and freely given, clear and specific. So this is one situation in which you can't rely on implied consent. The next lawful basis is performing a contract. So the processing is necessary to enter into or perform a contract to which the individual is a party. So for example, you need to process your customer's contact details in order to provide your services to them and contact them about your services. So you could rely on performance of a contract there. The next is legitimate interests. So this one is a little bit vague, and this is probably where if you don't have one of the other lawful bases to rely on, this is probably the one that most businesses would lean towards. For legitimate interests, the processing must be necessary for the purposes of the legitimate interests pursued by you or a third party, except where those interests are overridden by the interests or fundamental rights and freedoms of the individual, taking into consideration the reasonable expectations of the individual based on their relationship with you. So it is a bit of a balancing act, balancing your interests with the rights and interests of the individual, and sort of if your legitimate interests outweigh those rights and interests of the individual, then you can rely on legitimate interests as your lawful basis. And then we've got legal obligation. So this one is purely where the processing is necessary for compliance with a legal obligation to which you are subject, and that includes any employer obligations. We've also got vital interests. The processing must be necessary to protect the vital interests of the individual or another natural person. When we talk about vital interests, a lot of the sort of information in this area indicates that we are talking life or death situations. So the guidance from the ICO does say that where you are relying on vital interests, you can only do so where the processing is necessary to protect that individual in life or death situations. And then we've got public interest. So this would apply where the processing is necessary for the performance of a task carried out in the public interest or in the exercise of official authority vested in you. This kind of only applies to government authorities or public bodies because they are really the ones that have tasks that need to be carried out under official authority. Now, you should be keeping a record of the lawful basis that you've chosen and how you came to that decision so that if the ICO does ever come knocking, you have notes that you can refer to and let them know exactly how you came to a particular conclusion. So now that you know what your obligations are, how do you actually comply with them? For starters, you should make sure that you have the appropriate privacy-related documents in place, and we'll go through what some of those documents are now. So the first is your privacy policy. This is a document that tells individuals how you process personal data. It tells them what personal data you collect, what you use it for, and who you share it with. Your privacy policy should also include your contact details and information on the rights that the individual has under the GDPR. Excuse me. The GDPR specifically sets out what must be included in your privacy policy and how it must be made available to your clients. It must be freely and easily available, for example, on a page on your website. You should also be providing a copy to individuals when you collect their personal data. For example, if you have a contact us form on your website, you should have a little link near the submit button that says, we handle your personal data in accordance with our privacy policy available here. Similarly, if you are an e-commerce store and you have an online checkout page, you would have a similar reference to your privacy policy on your checkout page. So that's a privacy policy is between you and the individual that you are collecting personal data from. The next is a data processing agreement. This is a legally binding document between a controller and a processor, or a processor and a sub-processor, that states the rights and obligations of each party in respect of the personal data they share with each other and handle. So it sets out exactly who is responsible for what aspect of the processing. It sets out what instructions a controller is giving a processor in respect of the personal data that the processor is processing on the controller's behalf. And then it also sets out specifically what personal data is concerned, how long it's going to be processed for, and things like that. Your data processing agreement would also be where you have your standard contractual clauses or a UK addendum if it is considered a restricted transfer, which is a transfer of personal data outside of the UK to a country that is not considered to have adequate privacy legislation in place. Now, if you are a controller and you are sharing personal data with another controller, a data processing agreement isn't really relevant because it sets out obligations between controller and processor. However, you should still have a document in place, and we'd recommend that that be a data sharing agreement. So again, similar to a data processing agreement, it sets out what each party's rights and obligations are in respect of the personal data, but it doesn't specifically set out that one party is processing on behalf of the other party, because controllers in their own right are entitled to act as independent controllers. Now, if you are transferring personal data overseas, you should also have an international data transfer agreement. This is going back to what I said earlier about the standard contractual clauses. The standard contractual clauses is the EU version of it. In the UK, we call it an international data transfer agreement. Now, this is standard clauses that have been drafted by the regulators to protect any personal data that is moved to a jurisdiction out of the UK or the EU that the regulators do not consider to have appropriate privacy legislation in place. And like I said earlier, this standard language can be is made available by the ICO or the EU regulator, and it can be built into and incorporated into your DPA, so your data processing agreement. So there are some of the external facing documents that you should have. But then we also need to think about what you do internally. So firstly, we'd recommend you have an internal privacy compliance manual. This is an internal policy on how your business handles personal data. So it should include information about what types of personal data you collect, how you store it, and who is responsible for it. It should also set out what your team needs to do should you receive a request from a data subject or if there's a data breach. You would also have a data retention policy within this, so that tells your team exactly how personal data is going to be handled. So the way I like to think of it is a holistic document that tells your team everything they need to know about what your policies are relating to privacy, so that if they do have any sort of customer inquiry, they can simply look in that manual and know exactly what they need to be doing. So it should also appoint particular people or points of contact that are responsible for privacy within your business, whether that be yourself or another member of the management team, so that they know who to go to should they have any questions about the manual itself or your privacy handling practices. You should also have an employee privacy policy. This is similar to your external privacy policy, but it's tailored specifically for your employees. So it lets your employees know what personal data you collect and hold about them, what purposes you use it for, how you store it, and what rights they have in respect of it. Typically, it's often included as part of an employee handbook amongst all of the other employee policies that you might have. You should also keep a record of all of your privacy related decisions, and you would do this in an internal privacy register. So, some of the decisions that you might want to keep a record of include what lawful basis you have relied on to collect particular personal data, any data subject requests you've received, and any data breaches you've experienced, and any data protection impact assessments that you've completed. This will ensure that you have a proper paper trail and an accurate recollection should the ICO ever request any evidence of compliance from you. So it just means that in, say 4, 6, 10 years time, if the ICO comes looking, you've got something you can refer back to, because I don't know about you, but I probably wouldn't remember what happened 4, 6, or 10 years ago. So then let's talk about some of the practical tips of how you can comply. So, firstly, only collect what personal data you actually need from your customers, and don't collect any personal data that isn't necessary for your arrangement with them. So, like I said, you need to have a lawful basis, but you want to make sure, even where you do have a lawful basis, that you're not collecting information just for the sake of collecting it, if it's not really necessary for the performance of your obligations or one of those other lawful bases. And then, like I said, make sure you are identifying a lawful basis for each type of personal data you collect, and that needs to be done before you collect it. So it shouldn't be an afterthought when you're putting together, for example, your contact form or your sign up form. Make sure you're thinking about all of the things you're requesting on there, and they are actually all things that you necessarily need for the purposes of providing your goods or services. You should update your privacy policy every time your privacy practices change, or at least once every 12 months. And that's just to make sure that it's always up to date, that things haven't changed and accidentally slipped your mind, and that you are always staying transparent. You should review your contracts with suppliers to ensure that there is a data processing agreement included. And if there isn't, get one drafted. You should provide training to your staff about the GDPR and your obligations as a business and what their role is in ensuring and assisting you with your compliance. At the end of the day, chances are, particularly where you've got a team, that if you receive a request of some sort, it's going to go to a member of your team rather than to you directly. So you need to make sure that they're aware of what their obligations are and how they can help you comply with those obligations. And then lastly, make sure you've got internal documents prepared to allow you to efficiently respond to situations such as a data breach response plan. Now, I mentioned this earlier, but that's something that's typically included within your internal privacy compliance manual. And just having that policy in place makes sure that you are responding to anything that happens within the timeframes required. For example, like I said earlier, with the data access request, typically a 30-day timeframe to respond. But for something like a data breach, you've typically only got about 72 hours to report it to the ICO. So if your team know exactly what it is they need to do or where to look for when something does happen, and you've got those policies in place ready to go, you'll be well placed to make sure that you're tackling any of your privacy things as they happen and in a timely manner. So that concludes the main part of our webinar. You might find our publication on GDPR Essentials fact sheet useful. You can get a copy of it by scanning the QR code on your screen, or a copy of these slides will be emailed to you after the webinar, and you can download a copy then. You might also be interested in our upcoming event. Now, given Christmas, it is a little while away, but on the 4th of Feb next year, we are going to host our first webinar for 2025, and it will be on preparing your business for success in 2025. So I do think that'll be a really good one for all SME owners to get involved in. So we're going to answer your questions shortly. While you submit them, you'll notice there's a Q&A box that you can use to ask any questions that you have following the webinar. But while you submit them, we'll take a minute to tell you about LegalVision's membership. So by becoming a LegalVision member, your business gets unlimited access to our full team of 100+ specialist lawyers for all of your business's usual legal needs. It's like having your own in-house counsel for a fraction of the cost. Our team can assist you with unlimited document drafting and reviewing. So that includes all of those privacy-related documents that we've just spoken about today. We also provide unlimited advice consultations. So anytime you have a question about the GDPR or generally about your business, you can book in a call with our team and we'd be happy to answer those questions. You also get access to unlimited domestic trademark registration and a whole host of other benefits. As a LegalVision member, you won't worry about the cost of lawyers ever again. Think of it as having your own in-house counsel. We'll take care of all the business as usual legal work so you can focus on running your business. And if you are in-house counsel, we also offer a dedicated service to manage your high volume business as usual legal tasks. To learn more about how a membership can help you, request a free consultation when the survey appears at the end of the webinar. Okay, now I think we'll answer some of your questions. So, are there any differences between the UK GDPR and the EU GDPR? Largely, they are still the same. So, post-Brexit, the UK incorporated the EU GDPR into domestic law, and that's effectively what is known as the UK GDPR now. So largely they are the same currently. Should that change in the future, it is highly likely. The ICO has indicated that they might look to step away from the EU GDPR in the future. So that's a bit of a watch this space. But yeah, if you are compliant with the UK GDPR for now, you will largely be compliant with the EU GDPR as well. Okay. How does the GDPR affect the ability to capture personal data for us for continued targeting? And also, does GDPR apply when capturing US persons' data for use in the US? Okay, both great questions. I will address, I'll kind of split them in two and address them in twofold because they are sort of separate questions. Firstly, capturing personal data for continued targeting. The answer to this will largely depend on the circumstances. So, what personal data are you capturing? Who are you targeting? When you say targeting, are you talking about marketing or something else? Generally, as we've discussed earlier, you need to have a lawful basis to collect and process personal data. So if you have a lawful basis for capturing the personal data and for using it in the manner that you propose, then it may be okay. But like I said, it will largely depend on the specific circumstances of the arrangement. And then as for capturing US persons' data for use in the US, this is a good one. As a business incorporated in and operating in the UK, you are required to comply with the GDPR, regardless of where your customers are based. So whilst individuals based in the US may not have the same rights relating to their personal data, businesses the UK-based businesses are still required to comply with their obligations in the jurisdiction that they're incorporated in. So in this case, in the UK. If you are capturing personal data relating to individuals based in the US, and that data is only being used in the US and you want to avoid the ambit of the GDPR, you could consider setting up a separate US entity as part of your group structure. And that's something our business structuring team could advise on. Um, but to the extent that that hasn't happened and you are operating in the US through a UK registered entity, then yes, you do need to still comply with the GDPR. A follow on from one of the previous questions, do we still need to comply with the EU GDPR? So whether you need to comply will again depend on what it is that you're doing. So the EU GDPR does have extraterritorial effect, meaning that you will need to comply if you offer goods or services to individuals in the EU or you monitor the behavior of individuals in the EU. And then separately, also, if you have an establishment in the EU, then you obviously need to comply anyway. And then if you are a UK-based entity offering goods or services into the EU, you may also need to appoint a separate EU representative. So that's an important one to keep in mind. Our services are B2B only. Do we still need to comply with the GDPR? Great question. This is a common misconception. So if you only supply goods and services to other businesses, a lot of people think that you don't need to comply with the GDPR, and that's actually not correct. So the GDPR applies to the processing of personal data. Personal data is defined as any information relating to an identified or identifiable natural person. Whilst this wouldn't capture any data relating to a company itself, it does capture any data relating to individuals within that company. So, for example, if you're getting the names and contact details of your customers' employees for the purpose of providing your services, um, that is considered personal data, and you will need to comply with the GDPR in respect of that. Other things that might be considered personal data are things like job titles or professional social media profiles. Now, where your customer is operating as a sole trader, they're actually considered an individual under the GDPR, and any data relating to that business will be considered personal data belonging to that sole trader. Hope that answers that one. Okay, if we receive a data subject access request and responding to the request requires us to release personal data of other individuals, do we need to comply with the request? Um, this is a bit of a complex one, and I'd recommend that you seek legal advice before you respond to this particular request. Generally, just because responding to a subject access request requires releasing personal data of other individuals wouldn't be grounds for not complying with the request, but it is important that you don't release personal data of other individuals in your response because that could be considered a data breach. So you kind of need to balance and weigh up the rights of the different individuals in responding to this request. So firstly, you should make sure that you've identified the individual that the request has come from, and identified all the personal data that you hold about them. From that data set, you should then identify any personal data that relates to a third party or another individual. Where possible, you can redact or remove the personal data of other individuals before providing the data set to the requester. If redacting isn't possible or would kind of render that information meaningless anyway, you then need to consider other options. And that could look like consent, or it could look like giving a partial response to the requester. Like I said, a lawyer would be best placed to give you advice on this one after understanding the situation. So I would recommend that you book in a call with our team for some specific advice on this. Following the webinar, like I said, there'll be a little pop-up for you to leave your contact details. So if you fill that in, a member of our team can reach out to you and we can discuss this one further with you. I think that's probably all that we have time for today. Sorry if we haven't answered your questions, but if you do have any more questions or things you'd like to know about the GDPR, feel free to leave us your contact details and that question, and a member of the team can reach out to you and get back to you on that. Now, whilst this is a free webinar, we do value any feedback that we receive. So we'd really appreciate it if you could respond to the quick 30-second survey that comes up at the end. And then at the end of that survey is also where you can leave us your contact details, so that we can reach out to you to answer any questions that we haven't yet answered, or if you want to learn more about how our membership can help you. Thanks so much for joining us.